Going to trial might be the best thing for your personal injury case. Most people are terrified of going to trial. They think it means years of waiting, stressful courtroom drama, and a huge gamble with no guarantee. In this video, I'm going to show you why going to trial might actually be the best thing for your personal injury case, and how it can change the outcome even if you never step foot in a courtroom. Hi, I'm attorney Sharif Gray. Our law firm represents people across Virginia who've been injured through no fault of their own. We prepare every case as if it's going to trial, and we've helped our clients recover millions of dollars after serious crashes and life-changing injuries. If you or someone you love has been hurt, contact us today at 804-494-6908. We're ready to fight for you. So let me start with something that might surprise you. The vast majority of personal injury cases settle before they ever reach a courtroom. And on the surface, that sounds like a good thing. Nobody wants to drag things out longer than they have to. But here's the problem. A lot of those settlements happen not because the offer was fair, but because the law firm handling the case was never actually prepared to go to trial. They took the offer because going to court was never really an option for them. And insurance companies know this. They track which law firms settle everything and which law firms actually take cases to court. When they know that your lawyer has never tried a case or doesn't have the resources to actually go to trial, they have no reason to offer you the full value. Why would they? There's no consequence for lowballing you. They know that your attorney is going to take whatever they put on the table because the alternative was never on the table to begin with. That's how a lot of people end up accepting far less than what their case is worth and thinking it was the best that they could get. So what changes when the insurance company knows that your lawyer actually goes to trial? Everything. Insurance adjusters and corporate defense attorneys make calculated decisions based on risk. Every case that lands on their desk, they're running the numbers. What does it cost to settle now versus what could it cost if this case ends up in front of a jury? If they believe there is a real chance that your case will end up in a courtroom, the financial risk to them goes way up. A jury doesn't follow the same formula that an insurance adjuster sees. A jury sees a real person who was hurt. They hear about the pain, the missed time with their family, the medical bills, the way that your life was changed. And juries can award significantly more than what an insurance company would ever offer voluntarily. That risk changes the entire negotiation. When the insurance company knows that trial is a real possibility, they start doing the math differently. They start thinking about what a jury might do, and they start offering numbers that actually reflect the value of your case. So here's the thing that most people don't realize. Trial preparation is often the very thing that drives a bigger settlement without you ever having to walk into a courtroom. The willingness to go to trial is the leverage. The preparation is the pressure. And in many cases, that's exactly what it takes to close the gap between a lowball offer and a fair result. But what if the case does end up going to trial? This is where a lot of people get nervous, and we understand that. Most of what people know about trials comes from TV shows and movies, and that's not how it works in real life. In a personal injury trial, your lawyer handles all the heavy lifting. They're the ones building the case, presenting the evidence, and questioning witnesses, and making the arguments to the jury. Your role as the client is usually pretty limited. You may be asked to testify about what happened to you and how the accident affected your life, but your attorney prepares you for that ahead of time. It also doesn't always take as long as people think. Some trials wrap up in a matter of days. And when you have a legal team that has done this before, that has stood in front of a judge and jury, and knows how to present a case effectively, the experience becomes much more manageable than you'd expect. That's one of the reasons our firm's military background matters. JAG officers are trained to handle high-pressure courtroom environments, and that experience carries directly into how we try personal injury cases. So how do you know if going to trial is the right move for your case? There are a few situations where pushing to trial makes the most sense. If the insurance company is refusing to offer a number that's anywhere close to the real value of your case, well then that's one. If the evidence clearly shows the other side was at fault, but they're still lowballing you, that's another. And if your injuries are serious and the gap between what they're offering and what your case is actually worth is just too large to accept, trial becomes a real conversation. The decision to go to trial is always yours. A good attorney will never pressure you into it, but what they should do is walk you through the risks, the timeline, and the potential upside honestly, so you can make an informed decision. And in many cases, just being willing to take that step is what pushes the insurance company to finally offer what they should have offered all along. If you're wondering whether you have the leverage to push for more, give us a call for a free consultation. You can reach us at 804-494-6908. We'll look at your case, tell you what we think it's worth, and help you decide the best path forward. You won't pay us anything unless we recover money for you. And if you want to understand exactly how insurance companies try to avoid paying what you deserve, make sure you watch this next video.